Coleman. Katie, I turn to you first because it is your colleagues at the New York Times that have the scoop on this new filing. Trump's lawyers seem to have a new attack plan on Jack Smith classified documents case in Florida. What's this all about?
Yeah, so this is a pretty typical filing that happens before a trial begins, when the defense is trying to figure out what kind of information it's going to get. However, it's really telling because it always gives the prosecution a sense of what is the defense interested in, and of course that means what might they want to use to buttress the government's argument. In this case, we're looking at a couple of things, including the idea that some of this information might not have really been too damaging to national security. And this is not the craziest argument in the world. I mean, keep in mind, there's been a long-time argument that the government overclassifies things, that the government treats documents as that too many things are classified and too many things are classified at a high level. So expect them to kind of use that line of attack. Now, again, does that mean that he didn't break the law? You know, the letter of the law does not account for overclassification, but it's the kind of thing that a jury could be swayed by. You know, if a jury finds that, yes, Donald Trump took a classified document, but say it had already been widely reported in the news, that's not as compelling an argument that he destroyed national security. So that's one thing. And then he's going to try to show that the classification itself wasn't direct, that some of the documents were not directly related to, you know, sensitive defense information, which is the wording in the statute.
Charles, what do you think about all this? Because we should remember, this is taking place in Florida with Aileen Cannon, a very Trump-friendly judge, and a potentially Trump-friendly jury.
Well, it's a very interesting legal strategy for them to employ at this point, because what they're attempting to argue is no harm, no foul. As Katie just talked about, they're going to basically set up a defense that says, look, these documents were already highly classified in a way that they should not have been, and therefore the fact that Donald Trump held on to them should not be something that results in him being convicted criminally. The problem with that is what you look at when you see Jack Smith and the government's filings today. What they filed was they wanted to get information around cell phone data from the co-defendant, in this case, Walter Nauta, because what they're trying to do is basically say, look, we're going to line up where all of these documents were being moved and hidden and moved and hidden while the government was trying to recover them. And that directly undercuts the notion that you believe that having them wasn't the big deal that you're trying to assert that now that it wasn't. And that is a problem that Donald Trump is not going to be able to escape.
John, how does this new legal strategy fit into the narrative he's using on the campaign trail? And at this point, the campaign trail and the courtroom are basically the same place, and he's making the same argument in fraud and now in Florida. Well, it didn't hurt the banks. It didn't necessarily hurt our country. Then I guess I'm okay.
Right, no harm, no foul, I guess, right? As long as you think there was neither harm nor foul. But, you know, what you're seeing here is a merging of the public relations or the political strategy and the legal strategy. And, you know, it's working for him within the Republican primary here in Iowa. You may be able to see some snow behind me. Here in Iowa in the caucuses, you know, the vast majority of Republicans still like Donald Trump. You know, if you look at the polling, it looks like he's going to be around a majority of Republicans when they go to caucus on Monday. And, you know, folks basically believe that he's done either no wrong or nothing that he should be punished for legally.
Katie, Jack Smith's team also filed court papers today about witnesses and evidence that they want to present. What do you know about that?
Yeah, so it's interesting. They talked about the fact that they plan on calling several FBI agents as witnesses, which is interesting. I mean, that is very typical for the government to do. In most cases, an FBI agent will be a key witness when you're looking at a federal prosecution. It's really interesting here, though, because Donald Trump's rhetoric since basically the beginning of his presidency, certainly it's amped up today, is that the FBI is against him. He's been sowing misinformation about the FBI actually being the genesis of January 6th. He's talked about the FBI being the deep state and not to be trusted. So again, when these things began several years ago, people thought it was outrageous. But after years and years of that drumbeat, it really begs the question, how impactful will that rhetoric be when FBI agents are sitting in front of a jury? They're the government's key witnesses, and Donald Trump has convinced a huge swath of the country that they're completely untrustworthy. So that's one thing that Jack Smith filed. And then, you know, he talked about, you know, what kind of evidence he would or would not want to admit. But I really think that the FBI agents as witnesses, something totally typical, something that would never, raise a brow in any other moment in history. This will be a really interesting thing to see, as you say, in a jury pool that is inclined to believe the things that Donald Trump says.
Charles, Trump's immunity appeal, his latest appeal, I want to share what he said on Tuesday night, right after the appeals court hearing. Watch this.
If this case were lost on immunity, then I did nothing wrong, absolutely nothing wrong. I'm working for the country, and I worked on very hard on voter fraud because we have to have free elections.
Yes, we have to have free elections, but there was no voter fraud. Is he just trying to gaslight the legal system here?
Of course he is, not just the legal system, but as he's prone to do, he's also trying to poison the public narrative in terms of how they view his actions post-January 6th. And pre-January 6th, as a matter of fact. What he is now trying to do is basically connect his actions in the wake of January 6th as in terms of them being a part of his official duties as the president of the United States, so that they are more inclined to fall under a potential immunity claim. It's not going to work. It's not something that I think courts are even going to look favorably upon, and I don't necessarily know that it's going to be successful. But consider that he's also speaking to a different audience, and that audience is his acolytes, his followers, and potential voters who he wants to position them, or he wants them to position him as the Republican nominee.
Well, that audience are the ones who are best positioned to keep Trump a free man. Katie, a lot of us thought that we could get the ruling on the immunity claim by tonight, but we're still waiting. Is that surprising from this court?
I don't know that it's surprising. I mean, what was interesting is when you listen to the hearing, all three judges expressed a tremendous amount of skepticism about Trump's argument, his lawyer's argument that he was immune, but they all came at it from different angles. And so I suspect that what's going on is that they decide how they're going to rule. They're trying to figure out how much commonality there is. Will we see one argument that is, all three of the judges in lockstep? Will we see an argument where everybody agrees, but the judges are writing their own opinions with different, takes or variations on what's going on? And do they want Judge Chutkan to weigh in on any questions, which is another thing that's been brought up? Should some part of this, is there a world in which the district court should have to decide on something like whether or not Donald Trump was acting in his official capacity? And so I think what would be ideal in terms of, the public feeling like it had a ruling that everybody could feel good about would be as if everybody was in lockstep and they issued a ruling and it was unified. Whether or not we get that, who knows, but that could take just a little bit of time.
But Charles, for the average person out there, do I have this right? Trump's immunity claim is basically not that he is innocent of any of these things he's charged with, but as long as he's not impeached or convicted, he's allowed to do criminal stuff. Isn't that what he's saying?
That's right. That's exactly correct, Stephanie. And that's where I think his attorneys made a critical mistake. By trying to make this an issue of separation of powers, you created a space where you want this wide latitude for a president to do pretty much anything that he wants while he's in office. And then you leave it up to a political question as to whether Congress will actually impeach and remove him or impeach and convict. And I think that came out during the hearing on Tuesday when one of the judges asked them about using SEAL Team 6 to assassinate a political rival and what the implications of that would be. These attorneys have now painted themselves in a corner that is untenable from a legal standpoint by simply saying that the president should more or less have free reign, and the only check in terms of whether a criminal prosecution can ensue is an impeachment. And I think that is a bad strategy that is bound to backfire on them.